Hello, everyone. Good afternoon, good morning, good evening, depending on where you are coming from. My name is Carla Praid. I'm the Judith Bresler Fellow at the Center for Art Law. I'm very excited to welcome you all today to our Immigration Under Trump Strategies for Visual Artists. This is a workshop taught by attorney Rakhel Milstein. But before I hand it over to her, I would just like to take a brief moment to tell you a little bit about the center and the work that we do. So the Center for Art Law is a Brooklyn-based research and education nonprofit. We are dedicated to offering resources and programming to advance the arts and legal communities. Through our website, newsletter, and events, we disseminate information and update our audience on all things art law. So we have news, programs, cases, publications, and a lot more. The center also facilitates conversations and learning opportunities, such as this one. And we invite you to subscribe to learn more about our offerings and catch up on everything art law. You may also consider becoming a premium member of the center. Memberships are discounted for artists and students. It will allow you to access our case law database, receive free or discounted tickets to events, search a library of archived video webinars and workshops, and many other benefits. As to upcoming events, we are very excited to share some of the things we have planned for these coming 2 months. Next week, we will have our first copyright law bootcamp. This is a CLE event aimed at training copyright attorneys in the special needs of visual artists. We'll also be having an event in London. Our Atreya Mathur, who is here with me, she will be speaking at a roundtable on April 28th. You can join the event in person, but it also has an online component. So please do join us if you can. We also have clinics, which are events where artists can discuss their legal cases with attorneys. We have a copyright clinic coming up on May 14th and a legacy and estate planning clinic on June 11th. So I invite you to attend as many as you can and do stay in touch with us so you can learn about these and other events as they come up. We have a newsletter and also follow us on social media. Our handles are Center for Art Law and @It's Art Law. Before I hand it over to Raquel, just a few housekeeping items. We will be recording this event. You will receive a link to the recording after the session is over. We are also sharing with you on the chat a handout with a few extra resources for those of you who may be interested in learning more. And if you have any questions during the presentation, please post them in the chat box as they will be addressed at the end of the session. And without further ado, let me introduce you to Rakhel. Let me hand it over to Rakhel Milstein. She's CEO and founder of Milstein Law Group. We are very excited to have you here with us, Rakhel. Thank you so much for accepting our invitation. Just to keep it short, I will not read her full bio, but you can read all about her work at the handout that has been shared in the chat. Sorry. So I'll stop sharing my screen now, and please, Rakhel, welcome. And
thank you.
The floor is yours.
Thank you so much, Carla. I'm excited to be here. I know we have a nice small group, and I just want to reiterate what you were saying, that the Center for Art Law is such a fantastic resource for so many people, and not just those in the law, but obviously a fantastic resource for artists. We just had our annual conference, which was a huge success, and hopefully some of you will join us next year. Okay, so I'm an immigration lawyer. I've been practicing for over 25 years, and I'm here today to discuss primarily the O-1 visa and the changes that are going on right now with the Trump administration and its impact on immigration and O-1s. So I'm just going to share my screen and start a slideshow. Okay, sorry, a lot of pop-ups. Okay. So in the US, there are various options for artists, but there aren't a ton. And so when you're an artist in the US, many times you come here as a tourist and maybe you want to stay longer. Other times, maybe you're here to study and you want to also extend your stay. So there are various options. The O1 tends to be the go-to visa, and in fact, a lot of people like to nickname it an artist visa, but actually O visas are available to all professions. The O's are for people of, quote, extraordinary ability. There are also, though, P visas out there, which can help those who work in a field or an artistic form that is somewhat culturally unique. So this could apply, to visual artists, but also dancers, performing artists, singers, things like that. And then there are green cards, and there is a EB1 green card that allows you to self-sponsor. But for the purposes of today's session, I'm going to focus on O1B visas, but I want you all to know that it's not the only option available for immigrants who are practicing the arts. Okay, so what is the O1 visa? The O1 visa is a non-immigrant work visa, and it can be valid for up to 3 years at a time. A non-immigrant work visa means that it's not an immigrant visa, right? An immigrant visa means you're getting a green card. A non-immigrant visa is for any of you who are here temporarily. The O1 visa is primarily based on the evidence of your professional achievements and successes in your field. O1s, like all temporary work visas in the US, are specific to certain professions and certain employers. So what that means is once you have the visa, once it's been approved and you're here in the US on this O1 visa, you're only allowed to work in that particular profession. So again, if you're a visual artist and you're approved for an O1 visa as a visual artist, you can't suddenly start directing films. You can't suddenly start working as a barista. You're only allowed to work as a visual artist in the US. And this is the way that all temporary work visas are set up in the US. They're also specific to employers. Like I said, a lot of people like to call it an artist visa. Sometimes people call it a freelance visa, but those are misnomers. The O1 is one of the best visas out there simply because it gives you the most amount of employment flexibility. You can actually set up a case so you can work for multiple employers with just one visa. That's an anomaly. It's not usual. And so it really gives you the most amount of autonomy and flexibility when you're in the US working here. Well, here we go. So it does provide flexibility, and it's very important to arrange the case the way you foresee yourself working over the course of the next 3 years. Sometimes people don't have an option and you're only working with one employer because, it's difficult to find a lot of employment. But if you have that sort of luxury, then it's fantastic. I like to divide the O1 visa into two parts, just to give you a concept of how it's constructed, okay? About 10% of the case really focuses on your future plans in the US once you're on the O1 visa. And the remaining 90% of the case really focuses on your past achievements and successes. And this is really the crux of the case, how to demonstrate that you qualify under the law for an O1 visa. So to knock out the 10%, you need a U.S. petitioner. Who's the U.S. petitioner? In a traditional work situation, your employer sponsors you for a visa. Your employer is your petitioner. In the context of a multiple employer O1, your U.S. petitioner can literally be any U.S. person or any U.S. company. So the U.S. petitioner can be a U.S. permanent resident or a U.S. citizen. I think that the most important decision you make with your O1 case is selecting your petitioner. There are far too many people out there who try to pick someone who sounds prestigious or is, has a great reputation in the field or some sort of company that manages you. The truth of the matter is you want to pick someone you trust. They have power over your visa status for the next 3 years and can send a letter to immigration at any time requesting to withdraw the case and you have no visa. So immigration does not care what that person does for a living or what that company is. They just want to see that it's a US entity. So one big takeaway from this session is give it a lot of consideration when you're selecting your US petitioner because you want to make sure that person or that company has your back. But it's a work visa. And like all work visas, we have to show that you have work you're intending to do in the US. So if you want a multiple employer O1 visa, you want to have, my recommendation is at least 2 employment offers covering the course of the next 3 years. These employment offers can come from employers that are US employers or they can be foreign employers. as long as the work you plan to do on your O1 takes place inside the US. So one important little nugget about these employment offers is they dictate the duration of your visa. So if you only have employment offers for 6 months, you get a 6-month visa. So you want to ensure that you have at least one job offer, and it can be full-time or part-time, that spans the course of 3 years. The itinerary is a requirement in the regulations, and the itinerary is simply a summary of all the employment offers. That's all it is. So you don't need to sweat the itinerary until you have your employment offers already settled. Now, I keep saying offers because we don't submit binding agreements. There may be some attorneys who do, but you're not required to. So submitting these, we call them letters of intent. They satisfy the requirements of immigration, but don't actually bind you to these employers. So, for instance, let's say you want to quit down the line. You're not breaching the contract because it isn't a contract, right? These are a reflection of your plans. So they're not actually legally enforceable under the law. Okay. The second part of the case, which is really all about how do you qualify for an O1. In a nutshell, the law says you either have one major award or nomination, like an Emmy, a Grammy, a Nobel Prize, whatever it might be, that most of us don't have, or you need to satisfy 3 out of 6 criteria in the law. So I'm just going to pop them down here for you. One of the criteria, and I'm sure those of you who've discussed O1s with your friends have heard about needing press about you. Press is one category or one criteria in the regulation. So the press can be satisfied by either by press by you or about you. So if you're a writer, if you're someone who's a film critic, if you're a curator and you publish articles about exhibitions, whatever it might be, this category is great because if you do have articles about you or you do publish articles, you can satisfy this category with that type of material. There's another category that can be satisfied exclusively with letters of recommendation from experts in the field. So if you have some good contacts and they're willing to support your case and provide you with recommendation letters, that's another category. Another very common category is evidence of your critical or leading role in productions or events. So the problem with this category is we're limited with what types of evidence we can use, but a perfect example is you're a visual artist, you're exhibiting your work at different shows. If you have an exhibition history, the only evidence they'll consider for this category is promotional materials, advertisements, press releases, and newspaper articles or reviews. So they won't take letters of recommendation from people at the gallery or other experts in the industry for this category. So it's important to note because if you're not yet on an O1, but you're planning to pursue one, you want to make sure that you speak to these galleries or museums or other venues to ensure that your name is featured in any of the promotional materials before the event actually takes place. This category is very similar to the one I just mentioned. However, this is for organizations. So this is if you've been working at a company, so you performed a critical role for companies or establishments with distinguished reputations. This category does allow recommendation letters from colleagues, managers, people who have worked with you, who have firsthand knowledge how you've contributed to the success of their companies. So a lot of times this category is used in lieu of the first one simply because many times people don't have those promotional materials from the events or misplaced them, whatever it might be. So we can use recommendation letters for this one. The commercial or critically acclaimed successes category is a great category. It's sort of like a catch-all category because we can use any evidence of, big sales figures or things like that in terms of art sales or commissions. But we can also include any festivals or residencies or nominations, prizes, and also, again, newspaper or media coverage. So the critically acclaimed category catches it all. And I'm not sure if I just mentioned this, but film festivals is also a great one for that. And then lastly, which is our least frequently used category, is high salary. So if we can document that you earn more than the average or the highest paid person in your location for the work you do, we argue high salary. So stepping away from all of this, you should just understand that the structure of the O1 involves one U.S. petitioner, at least 2 potential employers, and then the evidence of your achievements. And the most common ones are the top 4, right? Or top 5. So the press by or about you, letters of recommendation from experts, and then critical roles and critical success. Um, okay. So how do you prepare for the O1? I can't tell you how many times I speak to people who say, I really need to talk to you. I really want to consult. My status is expiring, in the next 2 months. O1s take a lot of time. I was just talking with Trey about H-1Bs. H-1Bs can be done in about 2 weeks. A lot of visas can, but these types of cases are involved. They take time. There's a lot of variables. There's a lot of moving pieces. We have recommendation letters. We have a petitioner. We have potential employers. You also are required to get advisory opinions. So there's a lot of moving pieces, and as a result, these cases take more time than you may plan for them to take. So one of the most important elements is plan well in advance. Do not wait until you're ready to talk to a lawyer. Wait, you want to, the minute you start thinking about an O1, you want to reach out to a lawyer, schedule a consult, get your case assessed, and find out what you need to do to ensure that you're going to have a successful case. Because a lot of times people need more evidence, and that takes time, right? You need more exhibitions, or maybe you need more media coverage. So time is 100% the most important element with O1 cases. And then the second one is evidence. Okay, so how do you prepare? Time is essential. Prepare in advance. You can apply for an O1 up to 1 year before the requested start date. So if you're a student on OPT, well, the day you get your OPT, reach out to a lawyer, even if you don't think your case is ready, because you want to have some sort of plan set as early as possible. Evidence. The evidence is really what makes the case, right? So the evidence is important to collect and important to save. Now, tons of evidence these days is online or is in social media, and these things disappear sometimes. They're pulled down, they're taken, whatever it might be. So the minute that anything comes up that reflects the work you did, and when I'm talking about work, I didn't mention this, but it has to be work outside of school. So immigration won't consider academic achievements for these cases. It has to be professional work. My recommendation to everybody is create a Google Drive for your immigration case, and in that Google Drive, anytime you get a document, upload it as a PDF document so it's saved, it's not going anywhere, and you have that. So that by the time you're ready to start talking about the O1 case with a lawyer, you already have a file of documents ready to share. Because again, sorry?
Hi, Thomas, we're meeting at the pizza place.
Okay. I want some pizza. So anyway, so definitely save your evidence, because time and again, it disappears and people can't find it, and it's important. And this also includes contracts with employers, letters of recommendation you may have gotten in the past for scholarships or fellowships or whatever it may be. I can't emphasize it enough. Definitely save your evidence. And when you do, don't alter it. Immigration is very dubious about the authenticity of all the materials it receives. So you want to make sure that when you PDF a document, you're saving it exactly as a replica of the original. You're not putting in arrows, you're not putting in comments or highlights, you just keep it the same. The future employment offers are really important. And so one thing you want to consider is nurturing any kind of professional relationships you have with people, because they can serve as a huge part of your O1 case. They might be potential employers, they might be potential recommendation letter writers. So you definitely want to consider this while you're building a case in advance. And there it is. Okay, so that's really the nuts and bolts of the O1. Before I kind of pivot over to the Trump 2.0 issues, I just want to mention that an O1 case at our firm, at least, usually takes about 2 to 3 months to prepare. And then the Immigration Service takes about 6 months for regular processing, and they can process a case in 3 weeks if you pay them $3,000. So in an effort to sort of lower the budget of these types of cases and to prepare in advance, these are some of the reasons you want to start as early as possible. You're looking at a minimum of about 9 months just with regular processing. So the sooner you start, the more money you can probably save, and I guarantee you will be much less stressed out. Okay, so what's happened with Trump? Well, when it comes to O1 visas, the good news is, knock on wood, everything seems to be moving smoothly inside immigration. So when you file a case with immigration, it goes to the USCIS, right? The U.S. Citizenship and Immigration Services. From what we're seeing with processing times with O1s, they're moving as they always have been, if not even a little bit faster. I know there are reports of some people getting these crazy RFEs. What's an RFE? An RFE is a request for additional evidence. Whenever any case is submitted with immigration, you either receive an approval or an RFE. Sometimes they're unavoidable. It's like getting an audit from the IRS. Sometimes they are predictable because the case wasn't properly prepared. At our firm, RFEs come, they come not that frequently, but they come. It's just the nature of the practice. Um, so I've heard there are a lot more RFEs. We haven't seen them yet. I'm sure they're going to be coming our way too, which means that those can result in additional processing delays, right? So if you get an RFE, the case gets delayed, you need to prepare a response. Otherwise, I'm going to bring in some O1 issues when we get to the consulate section. The biggest, most important issue right now, today, on April 15th, 2025, is the travel issues for most people, right? So the issue is that for years, for decades, people have been traveling in and out with green cards, people have been traveling in and out with US passports, and people have been traveling in and out with visas. And today, it's just become a completely different situation for a lot of people. And before I even get into this nitty-gritty, I want you to know that the vast majority of people, foreign nationals, traveling inside to the US are not enduring problems, okay? This is a small minority of people, but it's a risk and it's an issue that we've not seen in the past. It's just much, much, much more prevalent. So what is happening? There are people who are on temporary visas, whether they're O's, tourists, students, even permanent residents, sometimes citizens, including immigration lawyers who are US citizens. They're sometimes taken to secondary inspection. So you go to the immigration line, you meet up with the officer, and he says, well, I want you to come to the side office for secondary inspection. Secondary inspection is standard practice when you're coming to the US and you're traveling on a temporary travel permit called advance parole. Let's say you're waiting for your green card to be processed. You come in with this travel document, standard practice. But what's happened today over the last 6 weeks or so is that people are being taken to secondary inspection who are on regular visas, have green cards, who've never had issues in the past, who've been living here for years, and now all of a sudden they're being pulled. I've had O1s that have said that they were taken to secondary inspection. They asked the officers, why am I here? And they were told that this is a new protocol in Miami. This was particularly in Miami, and that now we have to first get the green light from DC before we can let you through. Haven't seen it since. That happened about a month ago with the German national. There are people who are enduring additional questioning at secondary inspection. So beware. If you're taken to secondary inspection, you may be asked more questions. They may search your devices and look in your social media accounts, or they may not even ask you anything and just let you go after a few minutes. So it's very inconsistent, but you have to be prepared for that. In terms of the social media and device searches, they can search your device. So if you're a citizen, you can refuse that, right? So they have to let you in. If you're a permanent resident, you can also refuse, and they really shouldn't rescind your green card. They can't legally. You have to actually your green card has to be revoked through the courts. But they're trying to threaten people and scare people who are on permanent residence statuses. So that's something that's been happening. So there are a lot of people out there trying to give people advice as to what to do with your phones, your laptops, your iPads, whatever it might be. Some people are saying to lock the phones, but they may want you to unlock it. Some people are saying take away facial recognition. Some people are saying, well, delete your apps, clean up your social media. I mean, look, most of us don't have anything incriminating on our phones. And the reality is sometimes people are getting pulled for things that aren't incriminating, right? They're just your political viewpoint or your personal viewpoint or whatever it might be. So you need to be aware that there has been a massive uptick with this. And I actually have a handout or a document that discusses all of the social media searches and device searches that I'll put in the chat after this call or after this workshop. So that's something to really keep in mind. It's something that's unpredictable. Really, we don't know. But what I can tell you is the worst reports I've gotten is from Logan in Boston. The Logan Airport in Boston has been really, really rough with this. Same with Miami, Atlanta, but and my view is, and I think a lot of immigration lawyers agree, that JFK is one of the best ports, the best places to come in as a foreign national. They're just the most, I think, the most experienced and have the most information and understand the situation a little bit more clearly. Okay, so there is the travel, and then there is the consulate issues. So people, I mean, look, all my clients are from other countries. I understand you need to travel, you want to travel, but what I'm trying to tell people today, again, April 2025, is there's a lot of dust right now. If you can postpone any international travel plans for at least a few weeks, a couple of months, so once the dust settles, we can see what's actually happening at the port of entries and at the consulates. I think that's smart. The risk is small, like I said, because this is a small percentage of people, but it's unpredictable and there is a risk. So my advice is to try to refrain from traveling internationally if you can for the time being. Because the minute you leave the US, if you don't have a valid visa stamp in your passport, you're going to have to go to a consulate and obtain one. So what are some issues we've seen with the consulates? Well, there is definitely an increase in visa refusals, even for O1s. So that's something to consider. There are changes with the Dropbox requirements. So this was a system and is a system that allows you to bypass an interview at the consulate to get a new visa stamp, and you can mail them in. You can mail in your application with your passport, your approval notice, and you can get the visa issued without attending an interview. Well, I mean, I think this happened 6 weeks ago. Overnight, they changed the requirements for the Dropbox. So there were people who flew to India or flew wherever, all over the world, to renew their visas, and all of a sudden they were no longer eligible for this Dropbox requirement. So they ended up stuck outside the US for months because they had to attend an interview that they, could only attend months later because there are backlogs. So again, if you don't have to travel, you can avoid some of these complications by just staying in the US and postponing your travel plans till later once we have more clarity. There's also less information available. Okay, so there have been websites that tell you used to be able to Google visa wait times, and you could pop in the name of the city where you were going to apply and at the consulate, and you could see what the wait times were for different types of visas. It's gone. Websites are like disappearing. Transparency is, becoming more murky. So we're not getting the same kind of information we had even just a few months ago. Now, those sites weren't always that accurate to begin with, to be honest with you, but it was a way to sort of understand or gauge what you could, what your timeline may be for your visas. So know that things are changing without advance notice, without anybody having any idea of why or when. So it's important to constantly just check on the status if you are going to an appointment, make sure it wasn't rescheduled, and if possible, again, I know I'm being repetitive, try not to travel internationally right now if you don't need to. Actually, just last night, so it's happening by the hour, just last night, we got reports that now you can no longer schedule the date of your interview until you've actually completed the visa application for the consulate for your appointment. That's called a DS-160. This is the application that everybody needs to complete if they need a visa stamp in their passport. Well, until the day before yesterday, you could pick the date and then, go back to your application and complete it over a matter of days, and leave it incomplete. Today, you can't. You cannot schedule your interview until this has been submitted. I also got a report overnight that in London, there's now like a 48-hour waiting period before they'll issue the visa or schedule you for an appointment after submission of your visa application. So literally things are changing by the minute, which is another reason why if you can just postpone travel plans, it's the best thing you can do, because the minute you're gone, they're out of the US, it is so hard to come back if there are any issues. It's almost impossible if you have refused a visa at a consulate, for whatever reasons. There's very, very, very little transparency when it comes to consular decision making. And you can't even sue the consulates to find out why you were refused. There's this whole doctrine of non-reviewability, and it's really hard. So, well, this will take me to my next topic, which is, well, hold on. So I'm going to get into the student visa in a second. Processing delays. There are processing delays at USCIS. There are processing delays at these consulates as well. So I just went through the scheduling at consulates. Immigration adjudications are all over the place. Some cases are getting adjudicated in a matter of weeks, while others are taking years. So there's no consistency. And there's, again, no transparency in terms of predicting or anticipating processing times. And the same holds true with receipts. Then actually in December and January, we were filing cases, immigration lawyers were filing cases with immigration, and we wouldn't receive a receipt notice for like weeks, 4 weeks, 5 weeks. And these are people who may have been, their statuses may have been expiring. So in this new world of Trump and immigration, just know that this is now the norm for the time being. Hopefully things are going to get better. I am optimistic that hopefully things will start being processed more quickly, and we will have some sort of idea of what these processing times will be. A lot of O1s and other types of work visa cases, you can pay for their premium processing service. Like I said, it's expensive. It's almost $3,000, but that is the only way to really get a firm or a fixed timeline for your case in terms of USCIS processing. Okay, and then the F1 terminations, and this kind of tied in with the consulate discussion I was just speaking about. So I'm sure we all have read about this in the news, but over the last 2 or 3 weeks, a lot of people on F1 visas are getting notifications, getting emails from the government saying your SEVIS has been terminated. The SEVIS system is what really supports all F1 visas. So the schools manage the SEVIS accounts and State Department. So they were getting notifications that 2 things. One is your SEVIS was terminated or your F1 visa was revoked. And they are just hearing about it through emails, and a lot of people don't know what to do. In fact, 2 weekends ago, a friend of mine, her nephew, received one of these notifications. And there's a lot of anxiety it's causing. There's a lot of people who don't know what to do, because if you leave the US as a student on an F1, the chances of coming back with an F1 visa are really, 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 really slim. So at this point in time, there's a ton of lawsuits going on. There actually was a successful suit in New Hampshire where the Dartmouth student was reinstated with his F1 visa status. So his SEVIS records were reinstated. And I just know there's hundreds, I don't know if there are even thousands, but there are hundreds of lawsuits that are being filed all over the country right now. So I think by this time next week, we may have even better understanding of how we're all going to be advising and treating students in this situation. What came up with for me this morning with one of my one of my corporate clients is they just found out that one of their employees who's working for them on OPT, F1 visa status, had their status terminated. And now what does the employer do? Can the employer keep them on payroll? Is their OPT still valid if their F1 has been terminated? There's a lot of consequences to what's going on with this right now, and it impacts a lot of people, because there's also a lot of students who are married, who have spouses and kids who are on F visas. What happens to them? So the general recommendation at this point in time is stay in the US. They can't just terminate your status like this. It's illegal. So technically, if you're still a student and you should still attend class. You should still use your OPT until it's formally revoked by the USCIS. You have to actually get a notification formally revoking your OPT or your EAD card. So for the time being, like I said, this is this week, this is this hour. If you're a student, stay in the US, don't yet leave, file a lawsuit, get reinstated, hopefully. And I'm hopeful we're going to have a better understanding of this student status situation next week or maybe next month. And then finally, this is also, I don't want to cause too much anxiety here, but a new development with this Trump 2.0 situation is NTAs. The NTA is the document you receive when you're put into removal proceedings. That's called deportation. And this is the last thing any of us want to see. But what they've decided to do is to issue these immediately if your visa petition is denied. So let's just say you're on an O1, you file an O1 renewal. You're waiting for your new case to be approved, but your visa expired a week ago. And then all of a sudden, your new case gets denied. You're out of status for a week. They could issue you an NTA, and you're put immediately into removal proceedings. It's severe, it's extreme, and it's important to know, because one of the common issues of a visa denial today is not maintaining your status. And I think it's important in the context of the O1 visa to understand that. And in any visa situation, but when you're working for multiple employers, you still need to maintain your status. You're still on a work visa, so you need to be working. So if you're on a hiatus and all of a sudden you're not working with any employers for a couple months, you may not be maintaining your status. And if you want to renew your status later on, it may get denied and you may be issued an NTA because you weren't maintaining your status. So it's really important that you fully understand whatever type of visa status you hold, what the requirements are, because if you're intending to stay in the US past this visa status, you're going to apply for an extension or a change of your status, you need to ensure that you have sufficient documentation to demonstrate you have been maintaining status. So what does that mean? If you're a student, obviously you've been going to school, completing your degree. If you're an employee or you're on O1, you need to make sure that you're maintaining any pay stubs, any documents to show that you've been working, keep a history of any materials to document that you've been working in the US in accordance with your petition. And that is basically the nuts and bolts of it. I know that there's a lot of people that are really nervous. There's so much anxiety. I would say that I'm getting more naturalization clients from, my old past clients, people I haven't heard from in 20 years are reaching out saying, I want to get naturalized now because people are scared. I understand why you're scared, but this is not to instill any more anxiety. This is to just help you understand what your rights are, where you stand, and how the government is actually wrong in a lot of its areas, and especially with these F1 terminations. So just know your rights, make sure you have the right information. If you do, let's say you do get taken to secondary inspection, understand what you can and can't do, be ready for device searches and things like that. But know that the vast majority of foreign nationals inside the US or traveling to the US are not actually being impacted by any of these immediate changes. So it's just for a small minority. So you should just be prepared and be ready. So that's all I've got for you guys today. And I'm going to stop sharing my screen and I'm going to pop into the chat this little bit about device searches.
Thank you so much, Raquel. That was very, I'm sure the audience will find it very useful. It's great to have this whole thing mapped